If you're a naturalized U.S. citizen, there's one question that has probably crossed your mind this year, and it's not a small one. Can your citizenship actually be taken away? Curious. In 2026, immigration enforcement has intensified in ways that feel louder, faster, and more aggressive than anything we've seen in years. Files are being re-examined. Background histories are being digitally cross-checked. Old applications that once sat untouched in archives are now searchable in seconds. Social media is flooded with warnings. Group chats are filled with rumors about mass citizenship cancellations. Headlines are dramatic. The anxiety is real. But here's the problem. Fear spreads faster than facts. So before panic fills in the blanks, we need to slow things down and answer the question the right way. What has actually changed? What is legally possible? And who, if anyone, is truly at risk? Because there's a massive difference between political messaging and constitutional reality. Understanding that difference can be the line between unnecessary fear and informed confidence. Hi, I'm Artur, and on Immigration Monitor, I break down complex immigration policy changes into clear, practical explanations so you can understand exactly what applies to you and what doesn't. Today, we're going to unpack what's really happening under the 2026 immigration enforcement landscape, especially when it comes to naturalized citizens. I'm going to walk you through what denaturalization actually is, why older citizenship files are being reviewed, who is being scrutinized, what your constitutional rights are, and most importantly, what you should be doing right now to protect yourself. This isn't about politics. It's about legal structure, process, and facts. When enforcement intensity rises, clarity becomes power. By the end of this breakdown, you'll know where you realistically stand and where the rumors go too far. To understand what's happening in 2026, we have to separate two very important things: the law itself and how aggressively that law is being enforced. Since returning to office in January 2025, President Trump has made immigration enforcement a central priority again. Executive directives have emphasized stricter compliance reviews, expanded fraud detection, and deeper audits of past immigration records. By early 2026, federal agencies began allocating more personnel and more digital resources toward reviewing naturalization histories, particularly cases where there were potential inconsistencies, criminal omissions, or suspected misrepresentations in the original application process. That shift in attention has understandably caused anxiety. But here's the key point. The law governing citizenship has not fundamentally changed. There is no new statute that suddenly makes citizenship easier to cancel. There is no executive order that allows agencies to revoke citizenship with a keystroke. U.S. citizenship is protected under the Constitution. It cannot be taken away casually, administratively, or through a simple internal agency decision. This is where nuance becomes critical. There is, and has long been, a legal process called denaturalization. This isn't new. It has existed for decades under federal immigration law. Denaturalization allows the government to seek revocation of citizenship, but only under very specific circumstances. And most importantly, it requires a formal lawsuit filed in federal court. That means evidence must be presented before a judge. The government carries the burden of proof. The standard is high, clear and convincing evidence. And the individual has the full right to defend themselves with legal counsel. There is no secret administrative shortcut, no surprise cancellation letter that instantly erases citizenship. Without a federal court case, there is no denaturalization. That basic structure has not changed in 2026. What has changed is the intensity of review and the technology being used to conduct it. That is where the real shift is happening. Federal agencies are now using advanced digital cross-check systems that simply did not exist in this form a decade ago. Older naturalization applications, some filed 15, 20, even 30 years ago, are being digitally compared against criminal databases, travel records, asylum filings, visa histories, and other federal data sources. Paper archives have been scanned and integrated into searchable systems. Information that once required manual digging can now be flagged in seconds. If a name variation appears across documents, it can trigger a review. If a criminal charge existed before naturalization but doesn't appear in the application file, that discrepancy can now be detected far more easily than in the past. That technological evolution is one of the biggest reasons older cases are resurfacing in 2026. But here's the distinction that really matters. A flag is not a revocation. A digital alert is not a court judgment. It is simply the beginning of further review. For most naturalized citizens who were honest, met all eligibility requirements, and had no disqualifying issues at the time they applied, increased enforcement intensity does not automatically create danger. Technology may be stronger, reviews may be more thorough, but constitutional protections remain intact. If this clarification alone already makes things feel more grounded, stay connected here. The goal of this channel is simple: facts over fear, structure over speculation. And now that we've clarified what has actually changed, the next question becomes even more important. Who is truly being scrutinized right now? The answer is far more specific and far less dramatic than many online rumors suggest. So, who is actually at risk of denaturalization review in 2026? Not all naturalized citizens, not entire nationalities, not everyone who immigrated in a certain decade. Federal enforcement is concentrating on something much narrower and more technical. Whether citizenship was lawfully obtained at the time it was granted. That distinction changes everything. Denaturalization does not focus on what you did after becoming a citizen. It focuses on whether there was fraud, concealment, or material misrepresentation during the immigration or naturalization process itself. One major category receiving renewed scrutiny involves individuals who allegedly failed to disclose serious criminal history that existed before they naturalized, especially offenses that would have affected eligibility. The keywords here are serious and pre-naturalization. Minor traffic citations are not the target. Forgotten parking tickets are not the issue. Investigators are looking for undisclosed arrests, convictions, or criminal conduct that, if revealed, would have legally blocked approval. Another category involves identity inconsistencies, situations where different names, dates of birth, or biographical details appear across visa filings, asylum applications, green card petitions, or foreign records. In some cases, these inconsistencies are innocent errors. In others, they raise questions about intentional concealment. The difference matters, and intent becomes central in court. Marriage-based green card histories are also under review in some instances. If permanent residency was originally obtained through a fraudulent marriage, and that residency later led to citizenship, the entire chain can be examined. Again, the question isn't whether someone later became a productive citizen. The legal question is whether the foundation was lawful when it was built. There is also review of cases involving undisclosed affiliations with organizations that could have made someone inadmissible during the original process. These are not brand new categories invented in 2026. They have always existed in immigration law. What's new is the level of digital cross-checking that makes discrepancies easier to detect. Now, here's where fear often replaces facts. Not every mistake qualifies as fraud. The law requires that any misrepresentation be material. That word carries enormous weight. Material means significant enough that, if the truth had been known, citizenship would not have been granted. A typo on a form is not material. A short, forgotten trip abroad is not material. A minor offense that did not affect eligibility is not material. The government must show that the alleged concealment actually mattered to the outcome, and that is a high bar. So what happens if you're contacted? This is where understanding your rights becomes critical. If a federal agency believes there was fraud in your naturalization process, it cannot simply cancel your citizenship administratively. It must file a civil lawsuit in federal court. That is step one. Without a federal court case, There is no denaturalization. Once a case is filed, you have the right to respond. You have the right to hire an attorney. You have the right to review the evidence being presented against you. You have the right to challenge that evidence and present your own defense. And the burden is entirely on the government. You do not have to prove you deserve citizenship. The government must prove you were never legally entitled to it in the first place. Denaturalization proceedings are civil, not criminal. That means the standard is clear and convincing evidence, lower than beyond a reasonable doubt, but still demanding. However, if fraud is alleged, separate criminal charges could potentially arise in parallel proceedings. That's why early legal representation is not optional. It's strategic. If you are contacted informally, whether through a letter requesting additional information or even an unexpected visit, you are not required to answer detailed questions without legal counsel present. You can calmly state that you wish to consult an attorney before responding. That is not an admission of guilt. It is the exercise of a constitutional protection. You also have the right to appeal. If a federal court were to rule against you, the process does not automatically end there. Higher courts exist to review whether the law was properly applied and whether constitutional safeguards were respected. And importantly, if the government fails to meet its burden of proof on a specific allegation, it cannot endlessly retry the same claim without new evidence. The judicial system includes protections against abuse of process. If this explanation is helping you feel more grounded in the legal structure instead of swept up in online panic, stay with me, because next we need to confront the biggest myths circulating right now: claims about mass deportations, dual citizenship bans, and certain countries being targeted. Once we separate those rumors from reality, the full picture of 2026 becomes much clearer. Let's address the rumors directly, because misinformation spreads fastest when emotions are high. One of the biggest claims circulating in 2026 is that naturalized citizens are being mass deported. That is not accurate. Even with increased enforcement and expanded investigations, denaturalization cases represent a very small fraction of the millions of naturalized citizens living in the United States. These are individualized legal actions based on specific allegations tied to a person's original application, not broad sweeps targeting immigrant communities. The word mass generates clicks, but it does not reflect the legal reality. Another rumor suggests that speaking your native language, traveling back to your country of origin, or maintaining dual citizenship somehow puts you at risk. That is false. The United States does not require cultural abandonment as a condition of citizenship. You can speak your language at home, you can visit family abroad, you can maintain ties to your heritage. In most cases, dual citizenship is permitted if your country of origin allows it. None of those factors automatically trigger denaturalization. Citizenship is a legal status, not a cultural loyalty test. There's also confusion around criminal conduct. Here's the legal distinction that matters. Once you are a naturalized citizen, crimes committed after naturalization generally do not make you deportable. Deportation is a consequence applied to non-citizens. A citizen cannot be deported unless citizenship is first revoked through the court process we discussed earlier. Timing is critical. Criminal conduct only becomes relevant to denaturalization if it existed before naturalization and was concealed in a way that would have affected eligibility. That's very different from committing an offense years after becoming a citizen. Again, the focus is on whether citizenship was lawfully obtained at the time, not whether someone later made mistakes. Another claim circulating online is that certain countries are being unofficially targeted for citizenship review. There is no public statute or formal directive that strips citizenship based solely on national origin. Denaturalization requires individualized evidence tied to a specific person's file. While broader immigration enforcement priorities may focus on particular regions for visa or border policy purposes, revoking citizenship demands case-by-case proof in federal court. Ethnicity alone is not a legal basis for denaturalization. Some new applicants have also expressed fear that because interviews have become more detailed in 2026, Previously approved citizens could be randomly called back and retested without cause. That is not how the system operates. Naturalized citizens are not routinely re-interviewed simply because standards evolve. There must be a trigger, an inconsistency, new evidence, or investigative findings tied to the original process. Political rhetoric can sound sweeping, but the legal framework is narrower and more structured than many assume. So where does this leave you right now? Not in panic, but in preparation. If you are a naturalized citizen who disclosed your history honestly, met all eligibility requirements, and completed your process lawfully, your citizenship remains one of the strongest legal protections under U.S. law. That constitutional foundation has not disappeared in 2026. But stronger enforcement does mean preparation matters more than it once did. The first practical step is organization. Keep copies of your naturalization certificate, your green card records, and your original applications, including supporting documents. Maintain both digital backups and physical copies stored securely. Documentation becomes your strongest ally if questions ever arise. Second, if your immigration history included complex elements, prior overstays, name variations, past charges, or multiple filings under different circumstances, consider scheduling a confidential review with an experienced immigration attorney. Not because you are automatically in danger, but because clarity eliminates uncertainty. When enforcement intensity increases, knowing exactly where you stand provides stability. Third, respond promptly to any official correspondence. If you ever receive communication referencing your naturalization, do not ignore it. Do not assume it is a mistake. Do not attempt to navigate it alone. Early legal guidance can prevent minor issues from escalating. Silence does not resolve legal questions, it often complicates them. For green card holders watching this, the situation is slightly different. Permanent residents do not have the same constitutional shield that naturalized citizens possess. Status can be revoked more easily if serious violations occur. That makes compliance essential. File taxes consistently. Avoid criminal conduct. Maintain continuous residence. And apply for citizenship as soon as you are eligible. Citizenship is not just symbolic, it is structural protection. Immigration policy in the United States has always moved in cycles. Enforcement expands, courts review, political winds shift, legal challenges narrow or reshape executive actions. That pattern has continued throughout 2025 and 2026, with several immigration measures facing judicial scrutiny. The system of checks and balances remains active. Executive authority has limits. Courts impose standards. Due process still governs outcomes. Technology has evolved. Data systems are integrated. Historical inconsistencies are easier to detect. That is real. But constitutional safeguards are real too. Preparation is power. Knowledge creates stability in environments that feel uncertain. If this breakdown has helped you replace rumors with structure and fear with facts, share it with someone who needs clarity right now. Many people are reacting to headlines without understanding the legal framework behind them. Stay informed from reliable sources and make sure you're subscribed to Immigration Monitor so you don't miss future updates as policies continue to evolve throughout 2026. And if your situation involves unique complexities, consult a licensed immigration professional who can evaluate your specific case, because no video can substitute for individualized legal advice. Millions of naturalized citizens continue to live, work, vote, build businesses, raise families, and contribute across every sector of American society. Enforcement priorities may shift, but lawful citizenship remains one of the strongest legal statuses in this country. Stay informed, stay prepared, and as policies develop, I'll keep bringing you clear, fact-based updates so you can move forward with confidence instead of confusion.